So you've been charged with failing to provide a sample of blood in a drug driving case. Let's talk about one of the best defences that you can argue in a situation like this. It's what's called reasonable excuse. Now, reasonable excuse is a defence that applies in all fail to provide cases, including fail to provide drink cases. But in a drug driving investigation, and a fail to provide off the back of that drug driving investigation, that's usually going to relate to blood, because the only legal limits that exist for drugs relate to blood. So if you've been arrested on suspicion of drug driving, it's likely the police are going to want to take a sample of blood from you at the police station. And if you refuse and the police think you have no good reason for refusing, then they will prosecute you for failing to provide a specimen. Now, failing to provide is sometimes considered more serious than the original drug driving allegation. Drug driving generally carries a 12-month driving disqualification. Depending on the circumstances, most people are going to get 12 months as a driving ban. Fail to provide, generally the starting point is around about 18 months as a driving disqualification. There's also an increased risk of prison. So if you can defend a fail to provide allegation, it's well worth considering that because of the penalties for fail to provide offences. So you're taken to the police station, you're checked in first at the front desk, and you're taken through to the medical room where the police will then ask you to provide a sample of blood. They may or may not explain the reason why you're being asked to provide a sample of blood. They may or may not explain what would happen if you didn't provide a sample of blood. And that all relates to the procedure that the police have to carry out when a sample of blood is requested in police custody. If there's any issue with the procedure at any part in the process, that can be a complete defence to the allegation, and I'm always happy to discuss that procedure with you and explain whether you might have a defence on a procedural point. So the police have asked you to provide a sample of blood and you've refused. How do you defend that allegation in the courtroom? A phobia of needles. So if you've got a phobia of needles, a dislike towards needles, then you can raise that as a medical defence to challenge the fail to provide allegation. Now, if you told the police at the time that they were asking you to give blood that you don't like needles, and that really helps strengthen the argument, and that improves the chance of you winning the case in court on that basis. But if you didn't tell them, that doesn't mean to say that you can't argue that point afterwards. There may be a good reason why you didn't tell them. You may not have considered that to be a medical reason for not providing. You may not have been thinking straight at the time, and so didn't tell them for that reason. So just because you didn't mention that you have a phobia at the time that you didn't provide that specimen doesn't then stop you from arguing that point at a later date. Yeah, it's always better if you did, but you can still argue it at a later date. And I've certainly done that, and I've won cases by arguing it even later on without having mentioned that at the time. So the best way to establish that, to demonstrate that, two ways. First of all, medical records. If you've got a medical record that might show that you've got a phobia of needles, then even better. You're usually covered, particularly if those medical records predate the incident. So you might have gone to your GP and explained that you've got a phobia of needles, or it might be that you've previously turned down treatment because of the phobia. It might be that you've not had your COVID jabs because of that phobia as well. So clearly if it's pre-existing and you can demonstrate that, and that's always more credible, it's more believable, and it's more likely that you'd win the case on that basis. But how many people go to the GP and say, "Doctor, I've got a phobia of needles"? Very few, because you avoid doctor's surgeries, you avoid the hospital, you avoid the dentist if you've got a phobia of needles. That's the reason why you don't go in the first place. So not everyone has that backed up in medical evidence or medical records, and therefore that doesn't mean to say you can't argue it. Now, I work very closely with a psychotherapist who regularly produces reports in cases like these. And all it would usually take is that you'd sit down either face-to-face or over the computer with a psychotherapist. There'll be a short assessment that's carried out where she'll ask you various questions about the phobia, where you think it comes from, how it impacts decision-making, how it makes you feel when you see needles or where you're being asked to provide a sample of blood. And she'd then produce a really detailed report which can be used in court. And if the report is favourable and it confirms that in the psychotherapist's view you do have a phobia of needles, and that's the medical evidence that you can put forward to establish that. Again, it doesn't matter if it wasn't mentioned at the time, it doesn't matter if the report postdates the incident, it's always going to if it's a psychotherapist. So we put that forward, and that's really good evidence of a reasonable excuse. And it's also important to think about the burdens and who has to prove what in a fail to provide case like this. So first of all, the prosecution have to prove the case against you, and they have to prove the case beyond all reasonable doubt, and that's the same in all criminal cases. With certain defences that you put forward, there might be an evidential burden on you that you would have to discharge. So take, for example, a drink driving, post-driving consumption argument. You crash your car, you drank alcohol after the incident. In those circumstances, the burden falls on you to establish, on a balance of probabilities, that's a civil standard of proof, that you consumed alcohol after driving. And that can be tricky. You have to have evidence, and if the court don't believe you, they're not going to accept the argument. If you've not reached that standard of proof, they don't accept the argument. In fail to provide reasonable excuse arguments, what's helpful is that there is no evidential burden on the defendant. As long as you can establish an evidential basis for the phobia, and that could be a medical report, it could be the psychological report that we can produce after the event, then you've reached the burden. You've established that evidential basis, and it then becomes the prosecution's job to disprove the argument. So they have to prove beyond all reasonable doubt that you don't have a phobia of needles. The reason why that's extremely difficult, if not in some cases impossible, is because they won't have expert evidence. They won't have psychologists and psychotherapists that are producing reports in cases like these. They've got the option, but in very few cases will they ever do that. I've certainly never seen it. So if you've got expert reports that say you've got a phobia, you've got psychotherapist reports that say you've got a phobia, you've got witness statements from friends and family members that can confirm you've got a phobia as well. I'm sure friends and family members will be happy to do that for you, then it makes it really tricky for the prosecution to work around, because the burden falls on them to persuade the court that you don't have the phobia rather than you having to persuade the court that you do. So it's a really nice argument in fail to provide cases. It's not going to apply in all cases. If you've not got a phobia of needles, clearly you can't argue that point. But there may be other defences that you can fall back on instead, and I'm happy to explain those to you. So please get in touch. You'll find all our contact details online. You can request a call back and I'll call you back. Please comment, like, subscribe on the video. There'll be more to follow.